The Trump administration has declared war on the Constitution and is openly defying a United States Supreme Court ruling 9-0 against them, requiring them, commanding them to take all necessary steps to facilitate the return of Armando Abrego Garcia, who the government conceded, and 13 different judges already found that the Trump administration violated his due process rights and violated a court order to prevent him from being sent to El Salvador when they sent him to El Salvador, and he sits in jail now for day 30. There's new breaking news I'm going to report on now with 2 pieces of paper filed by the Trump administration. Both are, and they're inconsistent with each other. They completely try to rewrite the Supreme Court order, and they tell the judge to basically go F herself, that they're not going to do a darn thing, even though the president of El Salvador is meeting with Donald Trump today in the White House. Seems like a topic of conversation should be the return of Armando Abrego Garcia. I cover it right here on Legal AF. How'd we get here? On Thursday night, the United States Supreme Court 9-0 said that the Judge Xinis was right, that her order would be upheld, that her order for on due process grounds and constitutional grounds, requiring the Trump administration to facilitate the return of Armando Abrego Garcia and to report to the judge the steps that have been taken and will be taken to facilitate, that order is constitutional and enforceable. And that was the Supreme Court's ruling. They made another separate one-line ruling in which they said they didn't like the fact the judge used the word effectuate at one point. They said effectuate may be an incursion onto the foreign powers and foreign relation powers of a president or the executive branch. So what can you do about that, Judge? So when she got it back, she rewrote the order. She took out the word, the offending word. So no longer is there an effectuate, but there is a facilitate. And now the Trump administration has taken a position that facilitate only means what they're doing domestically. We changed the status, so if he ever shows up at the airport, we'll let him in. That's effectively what they're telling. But we're not going to do anything else because that would violate the sovereignty of El Salvador. And now we're into the foreign affairs, executive branch separation of powers problem. No, I don't see it that way. You can take all steps necessary to facilitate by making a demand or request on the foreign government where you have basically bought a storage unit to store human beings for the U.S. prison system. That's all that is. It's just a prison of the United States. It's being managed by the people in El Salvador and by the president of El Salvador. Invoke the contract. Contract is not sovereign immunity or sovereign issues. Call them up. Use diplomatic or other methods, whatever's at your disposal. Make the phone call. Send the email. Terminate the contract. Whatever you have to do to get him popped from that prison. Not that hard. And to take the position, well, we're at the water's edge. We can only do things domestically. That's how we interpret facilitate. That's not what the Supreme Court decision says. Now, one of the problems we're having with the Supreme Court decision is that it's only 3 paragraphs. Why is it only 3 paragraphs? Because Donald Trump stampeded the Supreme Court to make a decision by filing an emergency application. So they had very scant briefing, they didn't have enough briefs, enough filed case law, if you will, not enough record developed in facts by the judge below, and no oral argument. So you know what comes out of that? A little bit sketchy order that's hard to interpret, and leaves rooms for ridiculous interpretations by the Trump administration. Had they had more time and they issued a normal 30-page opinion with dissents, we would know what was going on. That's one of our problems. And that's on the Supreme Court for allowing it. But look, it's 4 paragraphs. We could all figure it out what it says. Let me just start with that. Here's what it says from 4 days ago, so that people don't think we're making stuff up here on Legal AF. Here's the actual order part of the order of the decision of the Supreme Court. 9-0, by the way. The district court's order remains in effect, but requires clarification on remand. Her order said she entered a preliminary injunction in the interest of due process and constitutional rights to require that the government facilitate Abrego Garcia's return. And the United States Supreme Court said, that's all great. We agree with you. We affirm you. The order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had it not been improperly sent to El Salvador. They just didn't like her use of the word effectuate, because that means maybe they have to go further, like send SEAL Team 6 in to have him get out of there. They're saying, well, facilitate, but you don't have to effectuate. You don't have to break into the prison, but you need to do everything else. But the Trump administration says, no, facilitate means whatever we can do on our end. We don't have to make a phone call. We don't have to send an email. We don't have to invoke our contract rights in that prison. We'll just change his status. So if he wanders out of El Salvador, by chance, we'll let him in. I'm not kidding. That's their position. That they asked the judge in the Supreme Court decision to clarify one issue. She used the word effectuate. She eliminated the word effectuate from her order. And here's what they file now. Let me start with their response to a motion for contempt that was filed on Saturday at the direction of the court by the lawyers for Abrego Garcia and for other information that they want in order to pursue their case. They said that they understand that they need to file a declaration giving the current physical location and custodial status of Abrego Garcia, what steps, if any, have been taken to facilitate his immediate return, and what additional steps the government will take and when to facilitate his return. They refused to give the judge any information about facilitation, what they've done, what they will do. They said, it's very sensitive, Judge. It's an incursion into our foreign affairs. We got a very sensitive situation here. Well, if it's so sensitive, then put it under seal and let the judge look at it in the dark. We call it an in-camera review. It happens every day in top secret classified cases. So we know that's not true. They also say, we're only going to tell you what we've done domestically. Only what we've done. We interpret it as domestic facilitation, meaning only what we do on our side of the border or our side of the government, not what happens in El Salvador. But even their own declaration they just filed doesn't do that. This new declaration by Evan Katz just tries to relitigate in an argumentative way the case law and the facts, which are already established in the record. It's just another legal brief filed by a fact witness. It's not a real affidavit giving any information about Abrego Garcia and the steps. They won't tell the steps that have been taken, despite 13 judges saying that they have to. Even their own filing says that they'll tell what domestic steps they've taken. Well, I've looked high and low in Mr. Katz's declaration, and it doesn't appear to be there. That's a problem for the Trump administration, because when they say on page 3 that we interpret defendants understand facilitate to mean what the term has long meant in the immigration context without any citation to any case law, namely actions allowing an alien to enter the U.S., taking all available steps to facilitate the return of Abrego Garcia is thus best read as taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. Indeed, no other reading of facilitate is tenable. There's no case law cited for this well-settled proposition. That usually signals it's not a well-settled proposition at all. They actually cite to their own papers for that position. And then anything else other than that, Judge, we can't tell you. Now, here's the part that really pisses me off on page 5. They have to admit, because it's public knowledge, that the president of El Salvador is arriving today to meet with Trump in the White House. They say defendants will continue to share updates as appropriate, as they see appropriate, apparently, not as commanded by the Supreme Court or the federal judge. Any further intrusion into this sensitive process and any directive from the court to take action against the nation of El Salvador would be inconsistent with the care counseled by the Supreme Court. That's a lie. First of all, what sensitive process, Drew Ensign? Are you talking about that there's negotiations underway to try to get his return and to facilitate? Well, then tell the judge that, even if you have to tell the judge that in a sealed filing and in camera and in private in her chambers. But you can't just refer to a sensitive process, an ill-defined, illusory, sensitive process, and hope we think that means, so what does that give us hope? And Abrego Garcia's U.S. citizen wife? There's a sensitive process going on. What is, pray tell, the sensitive process? That's not going to fly. And the rest of it is to basically go F yourself. In the filing by Evan Katz, who has to, every day there has to be a 5 o'clock filing, they basically say that he just completely rewrites and relitigates what the Supreme Court just said and takes a completely contrary position than what the Supreme Court ruled. That's not going to fly. There's a hearing on Tuesday. I'm sure the judge is not going to be happy on Tuesday. The Supreme Court is just sitting around until somebody asks them to do something. Nobody's asked them to further clarify because their 2-paragraph, 3-paragraph order is pretty clear. So Tuesday, I expect the judge to throw the book at the Trump administration. I'm sure she's waiting to see what happens Monday with Bukele. And if they try to argue, it's sensitive stuff, Judge, she'll say, great, meet me in my chambers. Tell me all about it off the record. And we'll seal it. That's the way you solve that problem. So continue to follow it right here on Legal AF. This is a fast-breaking story. It's going to be a lot even today with the Bukele visit and then on Tuesday with the hearing. Come back here for all your updates at the intersection of law and politics. Until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.